Great, we can
Good,
start.
great. Good morning, everyone. Thank you, Virginia. So I hope that everyone can see and hear me and us. Welcome to this webinar organized by BEPA on intellectual property management for battery innovations, a webinar that will be conducted by Alenka Zemi and with also Jean Lewis participating. So I'd like to start by introducing today's two speakers who will be teaching you more about intellectual property management within the battery sector. So Alenka Zemi is used to work for Lena Energy, where she organized their intellectual property portfolio, and that's where she got a real expertise and knack for intellectual property management within the battery sector. And she is now a consultant specializing on these questions. And we'll also have Jean participating today, who is now a consultant specializing in advising startups and SMEs within the battery space. So with that, I will directly leave it to our main presenter today, Alenka, to take over, and I wish you all a good webinar and to have the information that you were looking for.
Thank you, Timothy, and good morning, everyone. I really hope you have a refreshing beverage at hand because it's going to be a 2-hour journey. So my goal is to provide you with some essential knowledge and tools necessary to navigate this complex world of IP management in battery sector and also in general. So yeah, as Timothy already said, my name is Alenka Zemi, and I'm IP management consultant and also a funding specialist with a background in chemical engineering and postgraduate degree in intellectual property law. So I'm quite trained to address the both technical and legal aspects of intellectual property management. I'm also very happy and pleased that a good friend and colleague, Dr. Jean Lewis, accepted the invitation and joined us today. So Jean is the principal founder of Lena, a successful British startup developing solid-state sodium batteries for stationary applications. Later in the session, he will introduce himself properly and share his valuable insights. So this workshop is intended for everybody who would like to get familiar with the importance of IP and learn how to manage the IP for portfolio effectively with your organization. Throughout this workshop, we're going to explore various types of IP, understand the importance of IP management, and also discuss strategies to identify, also protect and monetize, so cash out IP through licensing. So today's workshop is organized into six sections, lasting approximately from 15 to 20 minutes. To keep things running smoothly, we'll have a 10-minute break in the middle and also a dedicated Q&A session at the end. So really the object, as we go through agenda, the objectives are understanding the fundamentals of IP, protecting IP, understanding the terms of consortium agreements, and I'm going to also share some good practice for IP management within funded project. We will also learn from successful IP case studies and learn about ownership, licensing, and also how to validate the IP assets. And at the end, I'm going to share with you various online IP management resources that can help you explore management further. So if you have any question during the workshop, just please type them in the chat, as the microphones obviously will be muted through the presentation, and Jean and myself will address them during the Q&A session at the end. So I'm looking forward to spending these 2 hours with you. So as an intro, I want to make clear the difference between IP manager, that would be me, for example, and the patent attorney, which are very often confused. So an IP manager typically works within company or organization and is responsible for managing the IP portfolio. So my role as IP manager includes developing and implementing IP strategies that aligns with the organization business objectives. Then it's also to identify potential potential IP assets. Then I also work closely with R&D teams and senior management to ensure IP protection measures are implemented within the company. Then IPM manager also collaborates with legal teams, such as patent attorneys, to secure and maintain IP rights. So IP manager usually serves as a bridge between organization and the legal world. On the other hand, then a patent attorney is a specialized legal professionals who provides guidance on the patentability. Then they do searches for freedom to operate and infringement risks. Then they also draft and prosecute patent applications to secure IP rights. Then they negotiate and draft IP-related agreements, such as licensing, confidentiality, and nevertheless, they also represent clients in any disputes and litigations matters. This is just to name some of the responsibilities, but the list is way longer than that. So let's start with understanding IP. So the understanding the various types of IP is really crucial for effective protection of your innovation and also creative works. I've divided types on registered IP, which are patents, trademarks, registered designs, and also unregistered IP types of protection that doesn't require registration, and these are usually trade secrets and copyrights. So patents protect novel and non-obvious inventions, including processes, machines, compositions, and parts of manufacture. A patent grants its owner the exclusive right to prevent others from making the same thing or using it or selling or importing. And it is for a limited period of time. Typically, it goes for 20 years. And in the battery industry, patent can be a patent can protect innovation in the areas such as materials, designs, and manufacturing processes. Then we get trademarks. So trademark protects distinctive brand elements. So these are names or logos or slogans. And trademark registration allows you to maintain your brand identity and also to prevent confusion and build customer loyalty. So that's the trademarks, and then we get registered designs. So registered designs are also a form of IP protection that protect the appearance, like the holistic appearance of the product. This is like a shape or configuration or patterns or any decorative elements that this invention has. So these designs can cover both the two-dimensional and also three-dimensional objects. And unlike patents, which protect the functional aspects of the technical solutions of a product, registered designs specifically focus on the visual elements that give this specific product a unique appearance. And registered designs typically grants its owner exclusive right to use the design for a specific period, usually up to 25 years, and it needs to be renewed every 5 years. And then we also have a copyright. So copyright protects, as already mentioned, creative works. such as softwares or technical drawings, marketing materials, also websites, sites, and PowerPoint presentations as this one. And the copyright owners have the exclusive right then to reproduce or distribute or perform any changes to original work. And copyright applies automatically upon creation, and registration is really not needed for that. And then we have this specific type of IP protection, which is trade secret, and I'm going to touch base more in that later. So trade secret protects confidential business information such as manufacturing processes or customer list, also any business, so financial data. And they are not protected for limited period, and then they do not require registration. Instead, you must take reasonable measures to keep the information secret, and these reasonable measures are using confidentiality agreements or implementing data security protocols. So in the battery industry, trade secrets can protect proprietary information on battery formulation or any specific manufacturing techniques that we don't want to disclose to anyone. And just for example, really famous trade secret is the recipe or formulation of Coca-Cola. So everybody knows the taste and looks of it, but no one knows the exact formulation for that unique taste because it has been kept secret for many, many decades now. Yeah, so it is really important to understand these distinctions between these intellectual property types, because that enables you to choose the most appropriate form of protection for your IP. And this strategic combination of filing for patents, trademarks, copyrights, trade secrets protection can help you really secure this competitive advantage in the market, and also it attracts investment if you need it. So IP protection ensures companies maintain control over their valuable innovation and protects your investment in research and development. So this is just to recap. So the IP protection gives you, first, as I already mentioned, is the competitive advantage. So a strong IP portfolio allows you to differentiate yourselves from competitors. And like this, you can then secure this very unique position in the market. And secondly, attracting investment, if you need it, then demonstrating ownership of key IP assets prove to potential investors, and also government funding agencies, that you really mitigated risk associated with intellectual property disputes. And then a strong IP strategy can then also significantly increase a company valuation and then securing funding. And then collaboration and partnerships. So well-defined IP rights facilitate collaboration and partnerships with other industrial players. So for that, it's important to have clear agreements on IP ownership and licensing in place, because this can leverage complementary strengths, and in the same time, it protects your company individual's interest. So let's move on to the case study. So we have this company, Lina Energy, UK-based battery startups, which really exemplifies the importance of IP protections for companies, like overall growth and also success. The company has developed an innovative solid-state sodium battery technology that promises higher energy density, faster charging, and improved safety compared to traditional lithium-ion battery. So it does exactly what is really needed in this energy-demanding world that we are living in. So let's explore the key aspects of Lena Energy's successful IP strategy. So they've created patent portfolio to protect its unique solid-state battery technology, and their patents cover various aspects of the innovation, including materials designs and manufacturing processes. Then the company registered trademarks in multiple jurisdictions to protect its brand identity. It's the logo and the name, as we can see on this slide, to make sure that the future customers can easily recognize and also trust their products when they're launched. And Lina also implements strict confidentiality measures to protect their proprietary information. That includes non-disclosure agreements, and they also implemented really secure data management practices. So no unauthorized access and so on. So our guest speaker will tell us more about the successful story of Lina, and he will explain how IP management contributes to investment when we're seeking it. So Jean, please, the stage is yours.
Alenka, thank you so much, and good morning to everyone. So I think before I begin, let me just kind of quickly explain my background, because hopefully it kind of explains the following slides, and I guess the sort of the slant that I have probably more to patents and thinking about keeping investors happy and getting investors on board. So my background, sorry, if Alenka, you could move forward a slide, please. Thank you. So my background, did a PhD at Imperial College in London many years ago, and that was in so it was in material science and specifically in fuel cells. And then with that sort of fuel cell knowledge, there was a spin out from Imperial. So I got into the sort of startup life very quickly. So I was employee number one of this company, and some of you may know, but Series has gone on to great things since. So I led the core research and development team, and from a patent point of view, I had my name on a couple of the core patents there, which I'm quite proud of. So from that, I moved to another fuel cell company, another publicly listed company, and I was the CTO there. So I had a very different position, and it was really there where I cut my teeth into IP and the importance of them, because of the role that I had. And so at AFC Energy, we were developing an alkaline fuel cell system. I guess the highlight there is that using what was then FP7 money, we designed, built, installed, and operated the world's largest alkaline fuel cell system at a Air Products facility. But the use of IP, there was a tremendous amount which was developed in that period. So developing a really kind of robust portfolio was very important, as was trade secrets and the other things which Alenka was talking about. So from that, I then I made the break from fuel cells, which was a great thing, and joined the lovely world of batteries, which doesn't involve hydrogen and things like that. So a very good decision. And I was the principal founder and CEO of Lena Energy, which Alenka's just been talking about. And so it was very key for us in the early stages, and many things as CEO, which I was kind of required to do, but one of them was really to build a strong patent portfolio. And I think really sort of the following slides are just to give a sort of an overview of some of the things which we did and learn on the way as we went from our sort of first core patent and grew that outwards. And just to kind of latterly say that I sort of recent career pivot. What I love is the kind of the early stage SME startup space. So I'm now working as a consultant, working with universities on some interesting battery tech. So I think the key thing to state is that I am not an expert in IP, and I think it's fair to say, so I'm please bear that in mind, but I do know a little thing about IP. I can ask the odd dangerous question, but I think what's really important is that if you go around this and what Alenka's talking about in the right way, you can build tremendous credibility, investment, and strong foundations for a business. which is in a very tight competitive space. So, Alenka, if you could move to the next slide, please. So, Alenka has mentioned that there are sort of many different types of patents. However, oh, sorry, IP. However, I think it's fair to say that patents get the lion's share of interest. And I think, put simply, investors, potential partners love patents. Alenka has already talked about the benefits. Let me just quickly go through them. I mean, so they show investors that a startup is innovative and it has the potential to lead in its particular area. It shows that a startup is committed to protecting its IP and it's commercially aware and commercially driven. It can increase evaluation and make it more attractive to investors, can give a startup a legal shield to protect their ideas and products, and it can lead to revenue through licensing. Importantly as well, it supports partnerships. It gives clear lines of division. This is what we're interested in. That's what you're interested in. And also, an interesting thing is it can help attract top talent. One of the things which I think has always been a little bit of a challenge is that when you're working in a sort of the slightly grey area of academia and startups, academics are often, they are rightly tasked with trying to publish everything they find, whereas I've generally been in sort of more recent years is you don't want to tell everything that you know, so that there is kind of a friction there. But patents are powerful, very, very powerful ways to build a CV. So what are some of the challenges though with patents? Well, I think the obvious one is that you are telling everybody what you're doing. To get a patent granted, you need to be able, someone who's termed as skilled in the arts should be able to replicate what you're doing. So you need to bear that in mind. It takes for a patent to be granted. So you need to think about, by the time that it's granted, is it actually still got any value? Because things change along the journey. It is a litigious process. If you make mistakes, it can have big consequences. So you do need to take advice. And a thing which was pointed out to me many, many years ago by a boss is that if you're an early stage company and you're at a point where you're having to defend a patent, you have already lost. It will take up all your money, and it'll take up a lot of management time as well. So just because you've got a patent, it doesn't mean that somebody's not going to potentially try and rip you off. You've got to keep moving. So, Alenka, if we could move to the next slide, please. So what I'm going to just talk about on this slide, there is a process for filing a patent, which is generally favoured by startups. And I'll just sort of take you through that. And I think why that there are many good advantages. So put simply, you file in, for our case at Lean, it was in the UK, but it could be your resident territory. And then that's a relatively cheap and easy process to do. Then after 12 months, you file a PCT. So PCT stands for a Patent Corporation Treaty. So it's one filing that goes into 145 territories. And then after another 18 months, you file at a national level. And that's where you decide which countries you want to then actually you want your patent to stay at. So why is this approach favoured? Well, one thing you do is you can quickly establish your priority date, and that's a real key date. That's the point you say this is ours. So even though it's still granted, oh sorry, you're still in the granting process, that's the date that you can refer to. A key part in this as well is that you get your first independent review within 6 months of that priority date. And that is really important from an investment point of view. And what I would kind of hugely recommend is if you are in a sort of the startup space, that if you can, try and get that examiner review before you start taking money from third parties. And the reason for that is you can look them in the whites of their eyes and say, we have got a third party expert who believes that this is novel. And that gives you a really good foundations for negotiations. So during the entire process itself, there's a couple of external reviews. Again, it gives you confidence in what you're doing is patentable, but equally you can use that to educate third parties. During this process, you have third-party visibility is delayed for approximately 18 months. So that's really good as well. So it means that once you've got that pattern in, you've got the clock is ticking, but you've got 18 months to carry on pursuing that idea before anyone else can then actually physically see that. And during that 18 months as well, you've got the possibility to amend your claims, not hugely deviate them, but it means that as you learn more through your R&D, that you can then strengthen them. This process as well, why it's generally really favoured, is in the first 2.5 years, the costs are relatively modest. So the national stage, the CT stage, costs are low. It's once you start filing at a national level, that's when costs really start to ramp up. So what's good about that is it gives you time to really, A, develop that patent further in terms of new R&D, get those claims stronger, but to really determine if that's something which is going to be good for your business, because things do change. And I think that's an important thing to consider. New ideas come along. Okay, so Alenka, if you could move to the next slide, please. So this slide here is the next couple of slides. It's really just sort of the story. I'll walk you through the sort of the first core patent as it's filed. And I guess just with a few sort of insights along the way. So the first key thing to do is this thing novel? You've got an idea, is it novel? So what you need to do is you need to discuss the invention's originality with the inventor, really try and get to understand, why is this good? Key question, can it be reverse engineered? And this goes back to Alenka's earlier points about, is this something which is a trade secret you want to keep in-house, or is this something where you do need to file a patent? This is something which would be pretty obvious, so therefore you want to get that protected. Now, at this point, if you can, you get your patent attorney to perform an initial search, and it's really good because they are an expert. And if there's something already in the public domain, they'll find it and they can give you some advice and potentially save you a lot of time and trouble later on. And then you need to make a decision. So, are you going to trade secret, or are you going to go for patent? And from my advice would be that it's something which will potentially spend a lot of money on. It has a huge bearing on the company, so it's something where you want to get C-suite sign off, or at least support in what you're doing. So let's say you've decided you're going to file a patent. So the drafting process, absolutely key. So ideally, the patent attorney works with the inventor, and you get them talking, and you go through a few iterations, and then you file the patent. So just a few things that I think are really important when you're drafting a patent is that a poorly written patent is basically pretty useless, and it can really come back and hurt you later on. So I really would encourage you to seek professional advice if you can. It's not that expensive. I've seen it where you get some people who maybe have an academic leaning, think that they can write a patent, and they spend a long time doing it, produce a long document, and it doesn't help anyone. So it needs to be someone skilled in the arts, needs to be able to replicate what you're doing. But you can be quite careful how you write the patent. So ideally, you want to have broad claims. You can use examples, which maybe throw people off the scent a little bit. There are definitely skills to writing a good patent. This is key. There is a temptation in your first patent to try and just dump everything into it to try and maximize your value. But don't do that, because reviewers don't like disparate claims. Also, a weak claim or point can potentially be really dangerous, because what that can do is that can stop you filing a future patent because you've already got something which refers to that. So be very careful about what you include. And I think a last point as well is when you consider the authors who go into the patent, it has to be only the people who've come up with the invention. So, if there's technicians who are involved in doing some experiments, no, they should go into it. Likewise, people who were in that key meeting but didn't contribute. And this is an important thing. So, Alenka, if you can move to the next slide, please. So we continue in the journey, and this is kind of a key part of the sort of first patent's life, I suppose to say. So between sort of 12 and 30 months. So at 12 months, you need to decide how you want to continue. Do you drop it? Do you just carry on filing in the UK or in the territory that you've filed in, or if you really think that there's still got some legs in it, is it do you put it as a single filing in something which is known as the PCT? This is 145 territories, and importantly, those 145 territories include all the biggies, like the US, like Europe, like China, etc. So, and I think that that decision is largely determined by the patent examiner's review that you get at that 6-month stage. So they will come back to you and say, this is really novel, brilliant, well done, which is really good. They may come back and say it's weak, the claim's quite narrow, or they may come back that it's not inventive at all and you shouldn't, there's no value in it. So really based on what they come back with, you decide what you want to do with that. And in if you have a good patent attorney, from that initial, even before you file the patent, you should kind of know where it stands. So it should be, if he does come back and it's really not inventive, you might want to question what the initial checks were. So what are the benefits of the PCT route? Well, I think one of them is it gives you 18 more months to decide which countries you want to file in, because as I said earlier, that's when costs start ramping up. As I said, it's possible to amend your claims, and that's really, really important. And it gives you that kind of additional 6 months in that sort of stealth mode, as I like to call it. So you've filed in the PCT, you've gone the additional 18 months, you're now kind of at sort of 30 months. And then you've got a real key decision to make, because you're at the point where you've got to start thinking about national filing. And this is, as I say, when costs start ramping up. So I think as some questions you really need to ask yourself is, does the invention still have commercial value? Do your claims need amending? Because this is your last chance to do it. And I would encourage the C-suite, the patent attorney, inventor get in at this point. And the key decision is which countries to file in. So the real key point here is that once you've decided which territories to file in, you cannot retrospectively go and add them. So you've got to lock that decision down. You can't in 3-4 years later on say, oh, I wish I'd have filed here. You can't do that. Territories, it's a tricky business. I remember I've done quite a few times. I've had a look and I was hoping that there would be something on the web which would tell me, working in a battery startup, where I should go and file which territories. There isn't. No two businesses are the same. And I think that as a general rule of thumb, if you've got a patent which you consider to be the crown jewels, probably in a region of about 5 territories. Medium value, 3, low value, 1. The one advice I was given was always consider filing the largest market out there, which is the US, partly because they are arguably one of the most litigious nations. So patent there is very strong, but also lots of competitors will think twice about trying to copy your technology if they know that they can't access the US market. So this is sort of the final slide on the patent journey. So Lenka, if you could just flick to the next slide. So we're kind of on the home straight now. We're sort of, it's the sort of 30 months plus. So this is the point, it's a national filing. So the patents are filed in specific territories. You then got what's called the prosecution phase. So you'll have discussions with the national examiners, and that can take up to 2 years. And then based on earlier searches, rejections, major modifications at this stage are pretty rare, which is good. Once you get it granted, you then have annual fees, and you need to pay those to maintain patent protection in each territory. So very important you pay those, because if you don't, the patent will lapse. I think it's really important, I say at the moment, that what I have described is a process which is typically used by startups, but you don't have to go the PCT route. You can straight off the bat go straight to the territories that you want to. However, you will start paying large amounts of money a lot earlier, and you don't have that stealth mode, and you don't have the ability to amend your IP, which I think kind of nicely aligns with the sort of the summary. So the process I've described, it minimizes large capital outlays, It gives key executive oversight, and that's a real key thing. Patents are expensive, and it's really important that the executive management team are involved in the key decision steps. It's important that this isn't just a technical thing which is kind of squirreled away. It's a commercial, a strong commercial vehicle. You can amend it, confidentiality, and fundamentally it is just critical for early stage companies. And the really cool thing is that once you finish with it, and you're probably sick to death with the patent, and then you get through these really cool certificates, and I have to say the Japanese ones are my preferred ones, and they look great when they go up on the wall. So moving away from patents, actually, sorry, not completely moving away. I think what is sorry, that's it. Thanks, Zelenka. So I think what's important, I've just talked about one pattern. What happens is that when you form a startup, you get your first pattern and that's into the system, and then you get some more investment, and your company starts to grow, as we did with Lena. So we started off with just a few of us who were ducking and diving. We won some grants, we got some investment, we recruited some people, we got more space, we got more kit, and then we started to generate a lot more patentable IP, especially in those first few years. And it is really important to establish the ground rules for a portfolio as early as possible. So I think some areas to consider. Alenka spoke about and then really it's at this point you really want to get an IP manager involved, because it greatly helps. So a culture of NDAs in place, very, very important. And it's important that you educate the team on that. And you have to think about, you might be recruiting people who've just started, they're early in their career, just left university. So you have to think about how you train people in that. Be careful what you sign up to in grants. Who owns the IPs? You really need to look at those T's and C's. Be very careful what you put in the public domain. You want to be promoting your company, your organization, but equally anything you put in the public domain could potentially come back and hurt you. So just be careful. Avoid a shotgun approach. So what do I mean by that? Don't just patent everything. Just, oh, that's a good idea. Let's patent that. Let's patent that. Really think about the areas of your business and try and ring fence all of your technology, so you don't have 5 patents in one particular area, but then have nothing in another area. So really think about the whole totality of what you're doing, and don't rush through a weak patent. Wait, make sure you do it right. So some advice. I mean, one of the things which I've always done is you review this portfolio at least once a year, where you just kind of step back. What is our patent situation? And I think it's really important that you need to challenge these assumptions. You need to, are we fully protected? Are there areas that we thought we were and they're not? It's really helpful because it enables you to budget. You need to think about, as I say, patents can start ramping up. So you need to be thinking about what's coming up over the next 12, 18, 24 months. You need to be really honest with yourselves. You need to be prepared to downgrade a patent. Sometimes something which you thought was the crown jewels actually isn't as good as you thought it was, because if there's been you're with the further R&D that you've learned more things. So you have to be prepared to do that. It isn't an exact science in terms of how you review your portfolio. And I think it's really important that you approach it with a multidisciplinary team. So you want tech there, you want commerce, you want finance. And if you can, look at what your competitors are doing. What areas are they patenting in? And also, you have to assume that they're looking at what you're doing as well. So be aware of that. So a really important part of the review is to rank your patents in importance. And you notice I use importance and not value. It's quite a difficult thing to do this. And it's really a combination of 4 factors. And this is something which is something that I have used because I think it helps come up with a good system. So, in terms of your patents, you have to ask yourself, what is the value of this from a monetized point of view? Does the IP offer a significant performance or cost improvement over competitors? And it needs to be significant. The invention quality, is the IP groundbreaking with broad novel claims, or is it something which is kind of an iteration on a theme? Longevity, it's a very difficult one to answer this, but is this innovation stable? And do you think that this is going to be with you for the whole journey? Or can you see that in a few years' time, with other R&D advancements, that it's not going to be as powerful as it used to be? And you need to think about, as a competitive edge, does this potentially block other competitors operating in your space? And that's thinking about how you ring fence. So it's really kind of factoring all those things. And I think what's really helpful with that is it enables you with the ranking, is it enables you to identify strengths, weaknesses, but importantly, areas of opportunity as well. So only a couple more slides from me. So last one, just I think it's important that it's not only about patents, there's also trade secrets. And I think it's interesting from an investor and investment perspective, their importance increases the further your startup evolves. So Alenka spoke earlier about the benefits and what a trade secret is. I think important I found that it can often be the most nuanced thing. It can be the critical solvent which goes into a screen printing material, or the temperature which just gets something to work. So they don't have to be, so it's those small little things. It can be the big things, but you want to get all of that captured. Similar to patents, not in a public domain. Alenka spoke about the importance about, you really got to think carefully about who has access to this. You need to have very strong controls processes in place. And this is where having an IP manager on board managing is essential. And I think it's fair to say that in Alenka, I've had one of the best, which has got me out of a whole load of trouble. And I think it's some of the nice advantages, or one of the nice benefits as well, is it forces you as an organization, a growing organization, to think about how you store data, and also how you share data, which has, I think, other positive benefits to the wider organization. And compared to the patent review, this is something that needs to be performed more regularly. Could be monthly, every 2 months, but it's very, very important that you review with the heads of the technical departments. Like patents, many positives to an organization. It protects unique innovations, ensures information stays confidential, secures the benefits, new ideas, processes. Well-protected trade secrets signal long-term value and stability. And what I found is that in the early stage of a company, high net worths who usually invest at a seed stage are less bothered about trade secrets. They're more bothered about patents. Once you start getting into sort of the more institutional money, Series A and beyond, they understand the real importance of trade secrets. Their importance cannot be yeah, they get it right. And obviously legal protection, it's really important, prevents unauthorized user disclosure. So just last slide from me, just a quick overview. So patents are, they're a competitive asset. Unlikely, you're unlikely to raise capital if not there. And also you need a pipeline that ring fences all areas. I would highly recommend a strategy based on national PCT for global coverage, as it allows amendments and defers costs, which is really helpful for an early stage company. It is cost and resource intensive, it's timely, and it requires strategic management and prioritization. But it is possible, it can be done. Portfolio management, regular review, rank patents by commercial value, and adapting to evolving business needs. A multidisciplinary team is absolutely essential, and be prepared to pivot. Don't throw bad money after a patent which isn't going anywhere. And don't forget to keep trade secrets up to date. Thank you, Alenka. Over to you.
Thanks, Jean. This was just really great. So Jean will also stay for the Q&A session. So if you have any further questions, just put them in the chat, in the Q&A chat, and he will answer later. So let's now explore the IP in the context of a grant-funded project. I believe that many of you came here today to hear about this. So Results from collaborative projects are often built on combined knowledge of a lot of partners, so it's jointly created and jointly owned. So therefore, it's important for partners to agree on appropriate and shared strategies for their management, their protection, and also exploitation. So before starting with a grant-funded project, it is essential to review the grant terms and conditions, particularly the consortium agreement or CA, because CA serves as the legal foundation for IP management. It provides this comprehensive framework that combines various innovation-related clauses. And these clauses cover essential aspects such as ownership. So you need to identify which party owns the IP generated during the project and how it will be allocated among the consortium members. So, and then there are access rights. So determine the rights each party has in terms of the use or development or also commercializing this IP. Then we have decision-making procedures and public guidelines. So here we talk about the confidentiality and publication. So we need to be really careful with restrictions on sharing project information on or publishing results. And the consortium agreement also explains the IP-related workflows and responsibilities. So why the consortia agreement? So the SIA not only establishes agreed rules to govern the rights and obligation of the collaboration within the consortium, but also includes reference documents like a background IP of all consortium partners. I'm going to talk about this a bit later. So it is really important to keep the agreement up to date and amend it as needed throughout the project. So when drafting the IP provisions, the primary goal should be to create this, like I said, flexible and efficient mechanism that will serve us as a tool for cooperation between partners. And typically for Horizon 2020 or Horizon Euro projects, the CI is based on existing model agreements, such as the DESCA 4 model agreement. And I'm going to share a link of this for you to look later. Because this really allows for more standardized process, and it makes it easier for the consortium to protect your valuable IP. So although it's not obligatory, beneficiaries of funded projects are really advised to agree in writing on the background before the grant is signed to ensure they have access rights to what is needed for implementing the project and also exploiting the project results when the project is finished. So the agreement might take any form. It might be a separate agreement, or it might be part of the consortium agreement. Because after a grant is signed, if beneficiaries owns valuable resources that can help in implementing the project, they should work together to reach an agreement on how best to utilize this during the project. So expectations, needs, contributions, benefits, and also risks should be openly discussed and also understood along with this project purpose or vision and concrete outcomes. So these projects really bring together partners with a wide range of interest, from research to commercial exploitation. This can be really challenging and complex when working with the universities and research organizations, because they prioritize publishing their findings, and small and medium-sized enterprises, so SMEs and other industrial partners, they usually focus on strengthening their competitiveness and growth of the company, and they would usually like to keep IP unpublished, because publishing too soon before we secure a proper protection can have like a severe consequences. And to overcome these challenges, it's now again crucial to define a suitable framework to organize and manage these innovation activities. So we need to maintain control over the dissemination and commercialization of the knowledge that we generated throughout the project. And also SMEs must be fully aware and understand the potential contribution of consortium partners and vice versa. So universities also need to understand what SMEs contributed. And then being clear about each partner's contributions and potential benefits that brings, then establish great project and finally release successful results. So please note that you shouldn't feel obliged to confine to the terms of the agreement, the consortium agreement at the beginning. You always have scope for negotiations. Just bear that in mind and negotiate. Because agreement is only a starting point, and partners can come to the agreement at any stage of the project. And it already happened in the past that company didn't want to join consortium agreement just because the IP provisions were loose. So it's essential that we clarify that from the start. And it's important that IP provisions continue after the end of the project. So include this into agreement. And throughout a project life cycle, different IP issues need to be addressed at each stage. So it's crucial that we have a clear agreement on existing knowledge that will be shared under terms and conditions. Because these assessments then allows on informed decisions regarding ownership and management and protections before we can start with the dissemination and exploitation. And in collaborative projects, the main exploitable outputs usually consist of a bundle of a result developed by partners individually or jointly. So let's see which IP needs to be addressed at each stage. So at the beginning of the project, you need to define existing IP, so background information, as I talked about. Then you need to assess the patent landscape and any other relevant IP rights. Then also identify opportunities and risk associated if you share your knowledge among consortium partners. Then during the project implementation, you have to consider existing and potential knowledge creation and also management tools. Then discuss various IP protection methods. So those are patents or copyrights, trade secret, or also defensive publication. And also consider their advantages and disadvantages. And finally, after project end, it is wise to discuss and agree on joint exploitation strategies, then examine possibility of ownerships or arrangements, including contributions of joint owners. And finally, evaluate potential licensing agreements and payment options linked to the use of IP resulting from the project. So let's just quickly touch base on the background and foreground. So background in intellectual property consists of a pre-existing knowledge, inventions, or IP that each partner brings into the project. And as already mentioned, these are the assets that partners have developed prior to the project initiation and which might be necessary to carry out project tasks. So background typically remains the property of the owner, so the partner who brought it into the project, and it's important to identify and disclose this information at the beginning of the project to avoid any misunderstandings or any conflicts over its use and ownerships at the end of the project, because that happens a lot. And then foreground IP, on the other hand, refers to the knowledge or invention or any other types of IP that has been generated as a direct result of a project. And this involves novel ideas or prototypes, any software or processes, or any other creation developed during the project life cycle. And foreground IP is typically owned by the project consortium or the partners who contributed to its development. And again, I'm emphasizing how important it is to establish clear guidance on ownership and usage and protection of foreground IP in the consortium agreement, again, to avoid any dispute. Okay, so just following the foreground, I just wanted to mention that project beneficiaries must now provide information on the owners of the results in the reporting. So this includes whether the ownership is a single or joint, then the name of the owners, the country of establishment of this IP, and whether the results will be exploited by the owners. And failure to do so will block the submission of the final periodic report and consequently the final payment. So be alert for that. So let's now move on the strategy for IP documentations. So regular internal reviews. The IP documentation strategy should include regular reviews of technical progress. And this can be done first by each party individually to determine whether the results that they've created lead to an original invention. In positive cases, then assessments will need to be made to determine whether this invention can be easily reversed engineered and then consider filing for a patent. Then we need to keep well-organized IP portfolio. So just maintain an up-to-date IP register or any database to track these project-related inventions or copyright or trademarks, and ensure that consortium members follows consistent IP documentation procedures. Then mark deliverables or any other project results data containing sensitive information as confidential or sensitive to protect the IP. This is really the easiest way. And then obtain approval from it's in most cases from the IP manager for public presentations to prevent any unintentional disclosure of sensitive information, because this would make invention unpatentable. And then we got also a dedicated IP manager. It's good that you assign a dedicated IP manager to oversee all that we've been talking about, because this will ensure that implementation of best practices and also efficient protection of your project IP is in place. All right. So IP register, I just mentioned databases for IP. So IP register should be as part of the strategy for IP documentation, and it should be established from the start. So this register should document background IP that is needed to undertake the project, and then also foreground IP, so the data gathered as part of the project. And then for each item of these IP, partners must determine the most appropriate method of safe and secure storage, and additional legal protection which will be recorded in the register. So if this is something that can be patentable or trade secret or something, just record it there. And it's best if all partners notify the IP register owner. So the owner is usually IP manager. So it's best if they notify them of any IP they've created as they go, because this information is going to be then compiled into the IP register, and it will be available to all partners. And also the review of the IP management and IP register, just put it as a mandatory agenda item for, I don't know, maybe every 6 month, 6 monthly partner assembly, or even less if you get a lot of new knowledge. So I already mentioned joint ownership because it presents a great challenge when managing or disseminating or protecting these research results. So even in cases of exclusive ownership, where one partner has the full ownership of the project results, for example, through exclusive license or any assignments, we need to have a specific provisions that ensures access rights for other parties as well. Because this will then protect the interest of all partners that are involved in the project. And any assignments of exclusive license require permission from all partners, and also must address cost and revenue sharing, revision rights, and any other relevant aspect. So establish a clear understanding of IP ownership among consortium members, and also develop strategies for protecting, as already discussed. So allocate IP ownership based on the project objectives and each member's contributions. And in cases of joint ownership, create a joint ownership agreement to clearly define the terms and conditions of this agreement. This agreement then should outline each party's rights, responsibilities, or any restrictions regarding the jointly owned IP. So this is also important to avoid or resolve any ownership disputes. You should keep documents such as lab notebooks to show how and when you produced the results. Or it's also good practice when you discover something, just send an email to self maybe with discovery information, because this is going to timestamp your invention. Okay, so licensing. So it's good to develop licensing and agreement strategies that then goes hand in hand with commercialization of the project results at the end. So establish licensing terms that reflect each party's IP rights and interests, as already discussed. Then negotiate agreements which really clarify revenue sharing, then the royalties, or any other financial agreements related to this IP exploitation, and include provisions for dispute resolution and termination in licensing agreements, just to address potential conflicts. And note that unless otherwise agreed in the consortium agreement or joint ownership agreement, each joint partners must grant non-exclusive licenses to third party so they can exploit the jointly owned resource. But the other joint owners must be given at least 45 days advance notice, and there also needs to be fair and reasonable compensations. So, okay, why take all these steps? So, beside each beneficiary's personal interest, there are also the EU Commission rules concerning the ownership, protection, access rights, also dissemination and exploitation of the project. So these are these are obligation to exploit, obligation to protect, and obligation to disseminate. So I'm not going to talk much about this, but I'm going to share a link so you can take exactly what these obligations means. And sorry for we run a bit over, but let's take now 10 minutes break, and we'll see each other again here a quarter or 16 minutes past 11. So thanks for now. All right, so the break is over. I hope you're all refreshed and ready for the second second time of the session. Oh, sorry, just the camera. So welcome back, and let's continue with identifying and assessing IP assets. So just let's explore some potential IP assets in the battery industry through a hypothetical example. So imagine a company called BETV, specializing in developing innovative battery technologies for electrical vehicles. Sorry, this might maybe come across as a repetition, but it's important. So patents are perhaps the most significant form of IP for a technology company, particularly for any hardware innovation. So BETV might develop novel lithium sulfur battery chemistry that offers significantly higher energy density and longer lifespan compared to conventional lithium-ion batteries. And yeah, this invention could be then patentable. So description of a pattern would be related to the composition and structure and the new battery chemistry, including any specific materials they're using, electrolytes, and also any methods for the manufacturing. And the benefit of patent for this innovation is then to prevent competitors from using the same chemical formulation and production techniques. So then BETV might develop a highly efficient, low-cost method for manufacturing the batteries. And here we're talking about a unique proprietary technique to scale the production of their solid-state batteries, which reduces waste and, increases yield. And by keeping this process as a trade secret, the company prevents competitors from replicating the production methods without the need for patenting, which would eventually make it public knowledge after 20 years. So second example of trade secret would be that the company could establish a confidential partnership with electric vehicle manufacturers and renewable energy storage firms, for example. And undisclosed partnership would be with a major automaker to provide batteries for their future life of electric trucks. So benefits of that is that protects the company's competitive position in business dealings because no one would know. And then, as already mentioned before, trade secrets are not formally registered like patents or trademarks. They are protected by ensuring to follow strict confidentiality measures within the company to keep them secure. So trademarks. So trademarks protect the brand identity of the company and its products. And this is to ensure that the customers can easily recognize them. And BETV registered its company name, logo, and also the name of its brand battery product line as a trademark. And this helps protect the brand's identity and like this prevents confusion amongst consumers in the marketplace. So they know exactly that they're using BETV products. And then we go to copyright. So for example, but we has developed proprietary software to optimize BMS, so the battery management system, or any charging protocols, this could be then protected by copyright. And the benefit is because it prevents unauthorized copying or distribution of this software. And the company's website design or brochures or any educational material might be also protected by the copyright. And the last one is industrial design. So battery collaborate with an industrial design firm to create a unique, compact casing for their batteries. And to protect this design, they register it as an industrial design. And the benefit, it helps distinguish their product better in this competitive market. And once you identified and registered all valuable IP assets, it's time to evaluate its value, which we're going to talk about next. So we'll further discuss the strategies for evaluating the value and strength of IP assets. So it's important to recognize this process. It's really complex, it's multidimensional, and it's often very time-consuming. But understanding the value of your IP is also important for any informed decision-making, portfolio management, and also for maximizing return on investment. So start by creating a comprehensive inventory of all IP assets owned or used by your organization. So this includes already mentioned patent, trademarks, and so on. So the key steps are list all IP assets and classify them by type. Again, patents, trademarks, and then ensure all IP rights are valid, active, and properly registered in relevant jurisdictions. So where you do the marketing or where your production is and so on. Then assess the market demand, then potential application and competitive landscape that is surrounding your IP assets. And the key question is this technology or brand behind that IP in high demand? Does it really address a key industry need at that moment? And also competitive advantage. So does the IP create a barrier to entry for competitors or give the company an edge in innovation or cost efficiency? So these are the questions. And also geographical coverage. So are the IP rights protected in all key markets where you operate or where you plan to expand? Then we have the patent landscape analysis. So just conduct a thorough search on existing patents in your IP domain, because that helps to identify the strength and scope of your IP by comparing it with existing technologies. And with that search, you will also discover any potential infringement risks, if there are. And assess legal standing and enforceability. So that means that you need to evaluate the legal strength. So these steps then ensures that the IP assets are defensible in the event of any infringement or any kind of legal challenges. And here you need to consult with a legal expert to determine this. Okay, so this key considerations here for the legal standing is the patent valid, then the strength of trademark. So that means are your trademarks distinctive and also widely recognized. And then for the trade secrets, do you have all the measures in place to protect your trade secrets? So NDAs, security protocols. Yeah, so that's on that slide. And then further strategies. So estimate the revenue potential or licensing opportunity, and also market share your IP could achieve, because this will help to forecast the future value and strength of your IP in the marketplace, because the financial value of your IP assets is really a key factor in determining your IP's worth. And the key metrics here would be how much revenue does the IP generate. This is either through direct sales or licensing or royalty agreements, if you have any. Then does the IP result in any operational efficiencies or reducing production costs, or does it streamline your process? And also, can the IP be licensed to the third party for additional revenue? And also, is there an interest from other companies or industries in your IP? And then benchmark against industry standards. So that means that you need to look at the patent citations. So how often is your patent cited by others in the industry? Because high citation rates can indicate that you really have very valuable or fundamental IP. Then there is brand recognition. So is your brand widely recognized in the market compared to competitors? And also, how does your innovation pipeline based on filed or granted patents compared to others in industry? So you have more or less or very strong patents and so on. Then consider IP liquidity and transferability. So ensure that IP ownership is clearly defined, and then check if there are any legal encumbrances, such as existing licenses or co-ownership that might complicate the transfer, or if you want to sell your IP. Okay, so yeah, just establish a clear licensing structure for any IP assets that might be used in collaboration or joint ventures. All right, so yeah, the main insights. So this process involves multiple departments such as RD, legal, marketing, to provide you a more holistic understanding of IP assets and also their potential value. So then aligning IP assets in the identification with the company's overall business strategy can help you to prioritize and protect the most valuable assets. So this is also an important step. And then continuous monitoring. So regularly reviewing and updating IP portfolios to ensure they remain relevant and valuable. And also assessing competitors' IP assets and strengths provides valuable insights into market trends and potential areas for growth. So this I see yeah, so this I see as the main insights in. And then the challenges with IP evaluation is that it is really resource intensive process. So it's time consuming, it's complex, and usually really requires significant resources and expertise. Then just to detect or determine whether an innovation is truly novel and non-obvious can be challenging, especially because this sector is changing so quickly. And then you need to have a good understanding of a global IP landscape as well. Yeah, so it's just navigating the ever-challenging IP laws and regulations across many jurisdictions can be a significant challenge if you file your patents in many jurisdictions. So this is about the strategies. And then let's move on the registration processes and timelines for various types of IP, because that's really important when you're protecting your invention. So I already mentioned that patent usually lasts for 20 years from the filing date, and it's a subject to renewals. So the process for patent typically takes 2 to 4 years to get granted. And it goes from the patent search, which usually takes from 1 to 4 weeks, and then drafting and filing application. I would suggest you work with experienced patent attorney, as Jean already mentioned, to prepare and file a patent application. Then examination. Yeah, it usually takes from 12 to 36 months, so it really depends, because the patent office examines the application for patentability, then often involves a series of any office actions and any responses. And then it's granting if the application meets all requirements. So this is on the patent. Trademark protection, it's faster. Usually takes from 12 to 18 months. And we would start again with the clearance search. That means that you need to perform this comprehensive search to identify your trademark and identify any potential conflicts with already existing trademarks. And then to file a trademark application with relevant trademark offices such as EU, IPO, or WIPO, like through the Madrid system, because this system facilitates the process to obtain IP rights in multiple countries through a single application. Then examination, it takes usually from 6 to 12 months, and then it's publication and opposition period, and finally the registration. Register designs, they usually, I'm saying usually because it depends on the jurisdictions. So US or China or Japan, they have a bit different rules as the EU or UK. So it usually lasts 25 years from the filing day, and it is also subject to renewals every 5 years. And the registration can take anywhere between 3 and 12 months from the filing date. And then we also have examination, publication, and registration. And we also have copyrights, which lasts for the life of the author plus 70 years. And the registration is not required. although you can do that, and that would then just provide additional legal benefits. Yeah, so now talk about the non-disclosure agreements. We talked about them when talking about trade secret and confidentiality. So why do we need them? NDAs helps to protect confidential information or trade secrets or any innovative ideas from being disclosed, or not just disclosed, but also misused by others. So NDA provides a legal framework for maintaining the secrecy of your valuable information. Then NDAs also create a safe space for open communication and collaboration between parties by setting the clear boundaries and expectation for handling sensitive information. This encourages then trust and transparency, which is essential for successful business relationships, especially when we talk about investments, and if they want to perform due diligence on your innovations. So then we get a legal resource. So if a breach of confidentiality happens, then NDA provides a legal basis for seeking remedies, such as damages. And this then ensures that there are consequences for unauthorized disclosure. Yeah, so it's also for maintaining the competitive edge by keeping your sensitive information confidential. Then you can prevent competitors from gaining insights to your strategies or plans or innovations. And in some cases, confidentiality measures are also necessary to comply with legal and regulatory requirements, such as data privacy laws or export control regulations or any industry-specific standards. And yeah, it's for facilitating due diligence, as I already mentioned. So yeah, to ensure effective protection, it's really important to draft clear and tailored NDA with specifically defined purpose. And additionally, you should implement appropriate internal controls, staff training, and data security measures to complement this legal basis that NDA provides. Okay. So now we're gonna just quickly, I'm cautious of the time. So we're quickly going to explore the essential tips for monitoring and protecting. So it is really important to implement robust cybersecurity measures, because this is to prevent any unauthorized access or any data breaches. So just use encryptions, firewalls, and access controls. Then keep an eye on website or social media platforms and online market places for potential infringements. And here also any kind of automated monitoring tools and AI-driven solution can provide real-time alerts if someone else is using the same trademark name or doing the same battery technology that you're doing. So it's just worth to keep an eye on that. Then we also have this digital rights. Digital rights management tools. So these DRM technologies are to protect the digital content, because these tools enables you to control access or use or distribution of any of your digital assets. And then again, educate your employees monitor domain registrations and trademark applications to prevent. So this is to prevent any cyber squatters or domain squatters from exploiting your IP assets online. And here it's important that you register your relevant domain names and trademarks in your key jurisdictions. This is to protect your digital presence. And just invest to secure channels for transmitting your sensitive information, such as encrypted email or secure file sharing platforms. Yeah, so it is really important to stay vigilant. All right, so we just came to the last section of our webinar. So I would like to share an overview of various online IP management resources that you can use, and it's going to help you explore IP management or conduct searches for patents, trademarks, deepen your understanding of IP. So we can take a look on the patent and trademarks databases like EPO or WIPO that I already mentioned. And also online platforms like Google Patents and the Lens offer access to vast collection of patent documents from various jurisdictions. Then we also have the copyright registration platforms or any legal resources, organizations such as Chartered Institute of Trademark Attorneys or the EU Patent Institute. They offer resources or forums for training. Then you can also access online communities and forums. And I'm going to share, I will copy paste some links to this, to these tools that you can take a look later. So from this slide, I really recommend for each organization to purchase this ISO 56005 standard, because it is a fantastic guidance for business with tools and methods explained for the IP management, especially if you're at the start of your IP journey. So I really recommend. I started IP management by reading this standard. And then we got different governance IP offices, and yeah, already mentioned that before. And here are some further links that you can take a look when the presentation is shared with you. So what I would really like you to take away from today's workshop, it's the importance of IP protection, because really a strong IP strategy is essential for protecting your valuable assets and maintaining competitiveness. Then types of intellectual property and registration processes. So it's about understanding the differences between patents, trademarks, copyrights, registered designs, trade secrets. That's really crucial for identifying which IP protection apply to your asset or innovation. And then also understanding timelines for various IP types. It's important, so there are no surprises if the registration takes longer as expected. Then it's developing an IP strategy. So your IP strategy should align with your company overall business objective. And trade secret management. You need to have really robust internal IP policies, employee trainings, access controls, and NDAs to prevent any unauthorized disclosure. Then we also talked about licensing and commercializations, because leveraging IP assets through licensing or joint ventures or technology transfer agreements can generate additional revenue streams, and expand your market opportunities if you go for it. And then we got monitoring for potential infringements and enforcing IP rights, because this is important for the value and also integrity of your IP. And then collaborate with IP professionals, because this is going to save you time and money. Then we just explained the importance of NDAs and implementing tools for monitoring and protection IP assets in this strong digital presence is also important. And just it's important to understand the terms of confidentiality, of consortium agreement, especially the difference between the foreground and background IP. Strategies for IP evaluation, if you would like to understand how much your if you would like to understand how much your IP assets is worth. I'm sorry, I'm repeating this with the NDA. And this was all from my side, and now it's time for the Q&A session. So if you have questions, just please type them in. I would also invite Jean to join. So let me just see. Okay, so so there was a question about the details on a trade secret register, what it should capture, and any tips. So so a trade secret. So a trade secret register should capture definitely a description of a trade secret. So a clear and detailed explanation of the information or formula or pattern, then the owner who invented this, who is the owner of this invention, and date of creation or a specific period when this creation was established. Then maybe potential value of these IP assets, maybe access restrictions, like who can access the trade secret and under what circumstances. Then you need to have a record of any NDAs or confidentiality agreements that are in place to protect these trade secrets. Then it's also wise to put the licensing and assignments. So just any information if you're licensing your IP, and that would be basically what I would say about trade secrets. Jean, do you have any question that you would like to answer?
So there was one from a Daniel about, it says there's a strategy recommended in order to select the territories for the PCT. So the PCT list is actually fixed, and the major territories which aren't included, the main ones, the main four are Taiwan, Pakistan, Argentina, and Venezuela. So basically everything else is there. So when you file a PCT, everything other than those four territories is there. The decision comes at the end of at the end of the PCT, is that when you then have to go for individual nations. So the PCT then doesn't file in all those individuals. That then kind of subsides, and that's the point you have to decide which specific territories you want to go into. So hopefully that answers that question. I think I saw an earlier question as well, Alenka, where somebody was asking about how do you decide whether something should go down a trade secret route or whether it should go down the patent route, and which I think, and it's that, is it the Coca-Cola recipe or not? And I have to say that that is very much determined by, each particular company has its own particularly unique technology. So I think a general rule of thumb that I always used to use is, if I assume that a potential competitor has got one of my cells or my technology in their hands, and they've got the means to open it up without it hurting them, then if they were to look at it, if there are things now which are so screamingly obvious, which is generally like, say, around design. So if it's, say, like the way that a current collection works, for example, that it's obvious that, and there is IP, then that's something that you probably want to think about getting patented. However, let's say that you've opened up a battery and you're looking at a black layer, which is, say, an electrode material. Now, in that black layer, there will be particular material that you've used, which comes from a supplier, which is the only supplier which provides a material that works. It may have a particular particle size distribution, surface area. There will be processing of that material. There will be solvents going into inks, which then will be lost through the processing. So all they will see is maybe a layer, but behind that, there's lots of nuanced things which are then lost and not obvious to reverse engineer. And that's the kind of thing that I would think about putting as a trade secret. What I would say is, I think you need to be careful that you have a patent. It doesn't mean that somebody's not going to try and copy you. A patent is only really of any value if you're prepared to fight it. So it's like the point I said earlier that, what a patent does is it marks your territory, but you've got to keep moving quickly. And I think equally with a trade secret, you can't assume that other development research teams, won't get there. It may just take time. So you have to be asking yourself, challenging questions about how much time does this buy? Because it is all about just trying to keep ahead of the market. So it's a little bit of a hand wavy answer, I'm afraid, but hopefully that gives you some feel on what we have done in the past.
Okay, so I collected some questions now. So there was a question: how do you know that you don't infringe on the IP rights of others, and what steps should you take if that happens? So you can avoid infringement by, as already mentioned, thorough searches for pre-existing IP. I think that's essential. And you need to do that before launching any new products or services or even names of your product. And then if, despite that, infringement allegations still happens, then it's really best to consult with an experienced IP attorney to assess the claims validity or prepare potential defenses, and if necessary, also negotiate a resolution or prepare for litigation. So I hope that answers.
And if I may just add, I think one more thing which is really useful there as well, and it's about working with your team. Often that your technical experts are ones who've actually developed that IP. They're probably world experts, and generally there aren't that many out there. So it's really important that you engage them. They may have been gone to conferences, they may have spoken to other people in maybe rival businesses or whether it's academic groups. They will have their finger on the pulse. So use your team as much as you can as well.
Yeah, so the next question: how can SME or startup manage IP on a tight budget? So it's a good question. And I think that you should always prioritize the most important IP assets and just focus on the most critical types of protection, which would be probably a patent. Yeah. And it's always good to seek the government programs for funding or any non-profit resources. Yeah, and of course, establishing a strong internal IP management processes. That's very, very crucial to go with that from the start. Okay. I hope that was okay. So yeah, I didn't emphasize much throughout the presentation, but there are a lot of public schemes that you can apply and get these additional grants or money to help you with your protection. So one of the question was related to AI and machine learning technologies and impact that has impact on IP management, and what strategy should you have to address these challenges. I really think that AI have the potential to significantly change the way we manage IP, because because you can be very efficient with the searches or trend predictions with the help of AI. So I would definitely encourage to use AI-driven tools to do that. And also it's wise that you update your internal policies in response to the AI-generated content. And it's also useful to follow any legal changes in response to the AI. So recently, I just noticed that U.S. Copyright Office has already indicated that AI-generated work will not be eligible for copyright protection. Yeah, so that's one. And there was a question about the risks and benefits for licensing IP, and also how to negotiate the terms. And I would say that IP licensing really offers opportunities for monetizing your IP, so to get cash out of it. And it can expand your market reach, but on the other flip side, you can face any infringements, you can lose the control of your IP, and consequently you can also face some potential reputational harm. So if you go this route, then just negotiate terms, the favorable terms for your organization, careful due diligence, understanding the market value, and also just set a clear performance metrics to establish any appropriate remedies if the breach occurs. Okay, so I'm actually cautious that we are running out of time. Yeah, I don't know. So there was also a question, advantage in registering copyright. So there aren't really a benefit of registering a copyright, and usually it's not necessary, but just in case of any infringement, it can help. It can add an extra layer of protection for the legal matters. So this would be it. I think that now with that question, we kind of finish this workshop. And I really hope you found today's session engaging and informative, and that you've learned something new, which will help you with understanding and implementing IP management. Although we couldn't address all the questions now, you just feel free to send me an email with any outstanding queries, and I will try to address them one by one. So thank you. And the presentation will be shared with you, and recording as well, if I was aware. And
yes, indeed.
yeah, all right. So have a good rest of the day, and hopefully to connect with you in the future. So bye.
Thank you so much, Jelenka. Thank you, everyone, and goodbye. Have a good day indeed.
Thank you. Bye.